let's kick things off by really digging into something we often take for granted. The incredible notion that just by being human, you're born with these inherent, undeniable rights. It's a concept so fundamental, it often feels like, well, like the air we breathe, always there, but its importance is only truly felt when it's threatened.
Right.
Today, we're taking a deep dive into the global tapestry of human rights, exploring them not just as abstract legal concepts, but as the very foundation of how we live and interact globally.
Yeah, the real world stuff.
Exactly. We're talking about rights that are universal, interdependent, indivisible, and that transcend all national, cultural, and political boundaries. It's been a long, complex journey, evolving from ancient ideas like Magna Carta, Enlightenment, natural rights,
Very long journey.
to this massive surge in recognition and formalization after the World Wars.
You've hit on something crucial there. What's truly remarkable is how those initial philosophical roots blossomed into concrete legal frameworks, particularly in the 20th century.
Right.
After the unspeakable atrocities of World War II, there was this collective, urgent international yearning to prevent such horrors from ever happening again.
Understandably.
It moved beyond just abstract thought. It became about forging a tangible global commitment. So our mission today is to first unravel that global architecture of human rights, and then we're going to zoom right into India's unique and deeply influential constitutional approach.
Okay.
You'll see how these foundational principles connect directly with your everyday life and shape the ongoing global dialogue around human rights.
So we talk about human rights today as a global standard, but I'm curious, how did that start to become institutionalized globally? Where did the real sort of game changer moment happen for international human rights?
That's an excellent question because the shift was truly profound. It absolutely begins with the United Nations Charter, signed back in 1945.
Okay, the UN Charter.
Before that, the idea of absolute state sovereignty often meant countries could largely do what they wanted with their own citizens without much international interference.
During internal affairs.
Exactly. The Charter bravely placed human rights right at the heart of the international order, challenging that old notion.
That sounds like a massive shift in how nations traditionally view their power. What did the Charter specifically say to, initiate this?
Well, the Charter's preamble boldly reaffirms faith in fundamental human rights, in the dignity and worth of the human person, and the equal rights of men and women. They're powerful words. But it went further. It explicitly mandated the UN to promote and encourage respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion.
So it wasn't just a statement of belief, it was a job description for the UN.
Precisely. It wasn't just a statement, it was a mandate to act.
It's one thing to state these ideals, though, but another to actually build a working system around them. How did the UN translate these, grand words into action?
Well, the UN didn't just state these ideals. It built an entire structure, an infrastructure, really, to promote them. You have key UN organs like the General Assembly.
With the big talking shop.
Well, yes, but it's constantly discussing human rights issues, adopting resolutions, approving new conventions. Very important work.
Okay.
Then you have the Security Council, the UN's most powerful body. It can even act on severe human rights violations if they escalate to threaten international peace and security.
So it has teeth, potentially.
Potentially, yes.
Yeah.
Then there's the Human Rights Council, which replaced the earlier commission in 2006, designed to be a more robust and representative body for monitoring and addressing violations.
Right, I remember that change.
And coordinating all of this is the UN High Commissioner for Human Rights, the OHCHR. They serve as the principal UN official dedicated to providing crucial assistance to states and overseeing these myriad activities.
Okay, so there's a whole system there. Now, after the horrors of World War II, as you mentioned, the world was really grappling with how to ensure something like that never happened again. I understand that led to the Universal Declaration of Human Rights.
Absolutely. The UDHR.
How did that document come about, and why was Eleanor Roosevelt's leadership so crucial in shaping it?
The world desperately needed a universal statement, something that articulated these rights clearly, a sort of moral compass for humanity. Under the powerful leadership of Eleanor Roosevelt, who chaired the drafting committee.
A remarkable figure.
Truly. The Universal Declaration of Human Rights, or UDHR, was adopted by the UN General Assembly on December 10, 1948. Her unique combination of diplomatic skill and, well, sheer personal conviction helped bridge a lot of ideological divides at the time.
And what does the UDHR actually contain? What kind of rights are we talking about?
It's a foundational text. It consists of a preamble and 30 articles. The preamble lays out the philosophical basis, declaring these rights are inherent to all human beings.
Okay.
Then, the articles break down specific rights into categories. You have civil and political rights, think right to life, liberty, fair trial, that's Articles 3 through 21.
The classic freedoms.
Exactly. Then there are economic, social, and cultural rights, the right to Social Security, work, education, covered in Articles 22 to 27.
More about well-being.
Right. And finally, Articles 28 to 30 include what are known as collective rights, like the right to a social and international order where all these other rights can be fully realized. It's remarkably comprehensive for its time.
It sounds like a really ambitious declaration, but if the UDHR isn't technically a binding treaty, like legally enforceable, does that limit its power in the real world?
That's a crucial point. It's often misunderstood. Despite not being a legally binding treaty in the traditional sense,
Right?
the UDHR is widely regarded as customary international law.
Okay, what does that mean exactly? Customary international law.
It means its provisions are so universally accepted, so fundamental, that they are considered binding on all states, regardless of whether they formally signed onto it as a treaty.
So it has power through acceptance.
Immense power.
Yeah.
It truly served as the foundational bedrock for countless other international human rights treaties, and has been deeply incorporated into the constitutions of many, many countries around the world. It's solidified its profound moral and, you could argue, legal authority globally.
So the UDHR was undeniably pivotal, providing that moral bedrock. But given its non-binding nature, as you said, it seems there was still a need to give these universal aspirations some real teeth. What was the next step?
You're absolutely right. That challenge, that need for legal enforceability, directly led to the creation of two legally binding treaties in 1966.
Okay.
These are the International Covenant on Civil and Political Rights, or ICCPR.
ICCPR, got it.
And the International Covenant on Economic, Social, and Cultural Rights,
Yeah.
ICCPR.
ICCPR, okay, two big ones.
These were designed specifically to translate the UDHR's principles into concrete, legally enforceable obligations for states that ratified them.
I often hear about negative and positive rights in this context. Can you sort of clarify that distinction for us, especially with these two covenants?
Sure. It's a useful way to think about them, though sometimes the lines blur. But basically, the ICCPR deals primarily with negative rights, things the government must not infringe upon.
Like hands-off rights.
Exactly. Freedom of speech, freedom of religion, freedom from arbitrary arrest, protecting individual liberty from the state.
Okay.
The ICCR, on the other hand, focuses more on positive rights, things the state should actively provide or work towards providing.
So hands-on rights?
You could say that. Things like the right to work, the right to health, the right to education. These often require the state to take active steps, spend resources, create programs.
That's a very clear way to put it. And it seems like those positive rights might be harder to guarantee sometimes, requiring resources and policy.
Precisely. And building on that point about teeth, these covenants provide mechanisms for accountability. The ICCPR, for instance, has two optional protocols.
Optional protocols, what do they do?
Well, the first optional protocol is really interesting. It gives you, as an individual, a direct line to the Human Rights Committee if you believe your rights under the covenant have been violated by a state that's party to the protocol.
So individuals can complain internationally.
Yes, under certain conditions. It's like an international appeals mechanism. The second optional protocol specifically aims for the global abolition of the death penalty.
And for the ICSCR, does it have something similar?
It does now, yes. The ICSCR also has an optional protocol for a communication procedure, allowing individuals or groups to submit complaints regarding violations of its provisions. It took longer to establish, but it strengthens the avenues for justice there too.
Okay, that makes sense. Now, beyond this global stage of the UN, we also see really significant regional human rights instruments. Can you give us a quick overview of some of those? Do they work similarly?
Absolutely. Regional systems are hugely important. Think about the European Convention on Human Rights, adopted way back in 1950. It created the powerful European Court of Human Rights in Strasbourg.
Which makes binding rulings, right?
Yes, its judgments are legally binding on member states, making it incredibly effective in many cases. Then there's the American Convention on Human Rights from 1969, with its own Inter-American Commission and Court.
And Africa.
And moving to Africa, the African Charter on Human and People's Rights, adopted in 1981, is particularly unique. It includes not only individual rights, but also people's rights, collective rights, like self-determination and the right to development.
People's rights, that's interesting.
It is. These regional instruments often provide more localized, sometimes more accessible avenues for protecting rights, adapting universal principles to specific regional contexts and concerns.
That's a fascinating regional spread, but it makes me wonder, why doesn't Asia have a single comprehensive regional instrument like Europe or the Americas? It seems like a pretty big gap on the map.
That's a thoughtful observation, and it's a complex situation. There isn't one simple answer. It's often attributed to the continent's vast cultural diversity, the incredibly wide array of political systems across its many nations.
Huge differences.
Huge. And in some regions, there's historically been a stronger emphasis on national sovereignty and non-interference. So this has generally led to a different approach focusing more on sub-regional agreements, like ASEAN's efforts and national legislation, rather than a single unified charter and court system for all of Asia.
So, a different path. Okay, so we've painted this broad global picture, these international standards. But how do these grand ideas translate on the ground? Let's bring it closer to home now. For a nation like India, with its own rich history, its freedom struggle, its immense diversity, how has this tapestry of human rights been woven into its very foundation?
India. Well, India's human rights philosophy is deeply, deeply connected to its long and often arduous freedom struggle against colonial rule.
Right, Gandhi, Nehru.
Exactly. Leaders like Mahatma Gandhi and Jawaharlal Nehru championed human dignity and individual rights long before the UN Charter was even a concept. Their thinking was profoundly influential.
So it was baked in from the start.
Very much so. When the Constitution of India was adopted in 1950, just a couple of years after the UDHR, it very consciously reflected a profound commitment to these values. It drew inspiration both from its own struggle and from those emerging international norms, incorporating a comprehensive Bill of Rights for its citizens right into the core document.
It sounds like human rights weren't just an afterthought then, but were really central to India's founding vision. What did the framers emphasize in the Constitution's core philosophy, in the preamble maybe?
Absolutely central. India's Constitution, from its very inception, deeply embedded human rights. The preamble itself really encapsulates the core philosophy ideals of justice, liberty, equality, and fraternity.
The guiding stars.
Precisely. It declares India to be a sovereign, socialist, secular, democratic republic, and it secures for all its citizens justice, social, economic, and political. Liberty of thought, expression, belief, faith, and worship, equality, status, and opportunity, and promotes fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It's a powerful, aspirational vision.
That's a beautiful mission statement. But okay, what does this all mean for you as a citizen in practical day-to-day terms? Where do these ideals become enforceable rights that you can actually claim?
Right, the practical side. Well, Part 3 of the Constitution is incredibly important here. It guarantees a set of fundamental rights.
Part 3, fundamental rights. Okay.
These are essential for individual development, and crucially, they are enforceable by the courts. That's key. Let's look at some key ones. First, the right to equality, covered in Articles 14 to 18. This ensures equality before the law and equal protection of the laws for everyone. No discrimination.
Foundational.
And importantly, this includes provisions specifically aimed at gender justice, prohibiting discrimination based on sex, and allowing the state to make special provisions for women and children. It also underpins things like the reservation policy for weaker sections, trying to address historical disadvantages.
Okay. And what about expression? Freedom of speech?
Yes, freedom of speech and expression is in Article 19.1, hugely important. And the courts have explicitly said this includes freedom of the press.
Critical for democracy.
Absolutely. However, this freedom isn't absolute. It's subject to reasonable restrictions for things like public order, national security, defamation, and so on.
A balancing act.
Always. And a very significant development here, recognized by the Supreme Court as part of Article 19.1, is the right to information, the RTI.
Ah, yes, RTI. That's been huge.
It empowers citizens to demand transparency from public authorities, a major tool.
Definitely. And the one I often hear cited as perhaps the most, far-reaching in India's constitution is Article 21. What does that guarantee?
Article 21.
Yeah.
Yes, it guarantees the right to life and personal liberty. Sounds simple, perhaps.
It does.
But its interpretation has been anything but simple.
So, the right to life and personal liberty under Article 21. You say it sounds simple, but I understand India's Supreme Court has given it a remarkably broad interpretation. Can you elaborate on how they've sort of expanded its meaning for citizens?
If we connect this to the bigger picture, Article 21 truly showcases remarkable judicial activism in India. The Supreme Court hasn't just taken the text literally, it's taken a very liberal and expansive approach.
Giving it life, so to speak.
Exactly, giving new and broader dimensions to this right. They've interpreted life not just as mere animal existence, but the right to live with human dignity.
Okay, dignity. What does that entail in practice?
Well, the court has read into Article 21 things like the right to a healthy environment, the right to free education up to a certain age, the right to privacy, which was a landmark judgment,
Huge one, yes.
the right to a speedy trial, even the right to basic medical care. It's quite extraordinary.
Wow.
This proactive judicial interpretation has profoundly broadened the scope of human rights protection in India, ensuring the Constitution remains a living document that adapts to contemporary needs. It's made these rights much more comprehensive than just a basic prohibition against, say, unlawful killing or detention.
That's a powerful expansion. Now, India, being a proudly secular nation, also has this incredible diversity of religions and cultures. How does the Constitution protect those aspects of identity?
Yes, secularism and diversity are core tenets. The Constitution ensures the right to freedom of religion, which is detailed in Articles 25 to 28.
Okay.
This means you have freedom of conscience and the right to freely profess, practice, and even propagate your religion, subject again to public order, morality, and health.
So freedom of religion, not freedom from religion necessarily.
Precisely. It protects religious practice. And beyond that, the Constitution provides crucial protection to minorities in Articles 29 and 30.
How so?
These articles allow linguistic and religious minorities to conserve their distinct language, script, and culture. And importantly, they have the right to establish and administer educational institutions of their choice. This really speaks to protecting the diverse and pluralistic fabric of the nation.
That's great to hear about the rights themselves, but what happens when these rights are violated? How does an individual actually seek justice in India?
Right, enforcement is key. A natural follow-up question here is the role of the judiciary, which is really the ultimate guardian of fundamental rights in India.
The courts.
The courts. Citizens can directly approach the Supreme Court under Article 32, which is itself a fundamental right, the right to constitutional remedies.
Interesting. The right to a remedy is a right itself.
Exactly. Or they can approach the high courts under Article 226. They do this using various writs. These are essentially legal orders from the court.
Writs, like habeas corpus.
Yes, exactly. Habeas corpus challenges unlawful detention, produce the body. Mandamus compels a public authority to perform its legal duty. Certiorari allows higher courts to review decisions of lower courts or tribunals. These are powerful tools for citizens to hold the state accountable.
So, direct access to higher courts. And are there any other institutions specifically tasked with protecting human rights? Like a commission?
Yes, absolutely.
Yeah.
Beyond the courts, there's the National Human Rights Commission, the NHRC. It was established by the Protection of Human Rights Act in 1993. Its role is primarily to investigate human rights violations, either suo motu, on its own initiative, or based on complaints. It can also recommend remedies and actively works to promote human rights awareness across the country.
So like a watchdog?
A watchdog, yes, and an advocate. It plays a vital role in ensuring accountability, even if its recommendations aren't always binding in the same way a court order is.
Okay. So we've covered these fundamental rights which are enforceable. But beyond these rights, India's constitution also reminds us of our responsibilities. You mentioned something was added later.
Yes, that's right. In 1976, through the 42nd Amendment, fundamental duties were introduced into Article 51A.
Fundamental duties. Okay, could you give us some examples of what these duties are?
Certainly. This article lists 11 duties for citizens. They include things like respecting the Constitution and its ideals, the national flag and anthem, promoting harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional diversities, protecting and improving the natural environment, including forests, lakes, rivers, and wildlife, and cherishing and following the noble ideals that inspired India's national struggle for freedom.
It's quite a list, a powerful reminder that citizenship involves responsibilities too.
Exactly. It's a reminder that rights and responsibilities often go hand in hand in a functioning democracy.
That's an interesting concept, having duties listed alongside rights. What was the thinking behind including them, especially adding them later? And are they enforceable in the same way fundamental rights are? Can you be taken to court for not doing your duty?
Good questions. Delving deeper into that, the realization that rights often come with corresponding responsibilities was key. The thinking behind adding them, particularly in the 1970s, stemmed partly from a feeling that while the Constitution provided an extensive array of rights, citizens also needed to be reminded of their obligations towards the nation and their fellow citizens.
This sort of moral compass?
A moral and civic compass, yes. They act as a constant reminder to individuals of their obligations while they're exercising their rights. Now, about enforcement, this is important. Fundamental duties are non-justiciable.
Non-justiciable, meaning?
Meaning you cannot be directly taken to court and penalized solely for violating a fundamental duty, unlike a fundamental right. They can't be enforced by writs.
Okay, so they're more like guidelines.
They are guidelines, but they're not legally irrelevant. The judiciary can, and does, use them as a guide to interpret laws and to test the constitutional validity of various statutes. For example, a law promoting environmental protection might be seen as upholding the spirit of the fundamental duty related to the environment. They also serve as a crucial guide for the state when formulating policy and legislation for the welfare of society, ensuring a more holistic view of citizenship that balances rights with responsibilities.
So bringing it all together then, we've traced this incredible arc, haven't we? From deep philosophical ideals about human worth through the creation of a robust international framework after WWII, championed by the UN.
The Charter, UDHR.
With cornerstone documents like the UDHR providing that moral foundation, and then the ICCPR and ICESCR adding those legally binding obligations, setting universal standards.
The whole global architecture.
Exactly. And then we zoomed in on India, seeing how it not only wove these principles deep into the fabric of its own constitution from the very start, but has even expanded on them through powerful judicial action.
Especially with Article 21.
Especially Article 21, yeah. And its clear commitment to fundamental rights, religious freedoms, minority protections, all while acknowledging those fundamental duties. It's a compelling journey. It really reiterates the universality and interdependence of these rights, showing us that what starts as an idea on a global stage can profoundly shape the daily lives and legal realities of billions.
It really does. And this brings up a point I've always wondered about, maybe a final thought, and it's really a question for you, our listener, to ponder.
Okay.
Considering this delicate balance within India and arguably in many democracies, between the enforceable fundamental rights, the ones you can go to court for, and the non-justiciable, more aspirational fundamental duties, what do you think is the ultimate responsibility of a citizen? How do you personally uphold the spirit of human rights in your daily life, both locally, in your community, and maybe even in contributing to that broader global understanding we've been talking about?
Rights and responsibilities in action.
Exactly. How do we live these principles, not just rely on the law? It's a thought worth mulling over long after our deep dive today.